Hello and welcome to this first video from your course, Introduction to Drafting. First, let's talk about what drafting is. The word drafting can even be used to describe a lawyer writing an email. So it indicates a specific kind of writing, the kind of writing that lawyers do. And this type of writing is done in recognized forms, such as contracts, pleadings, and legal notices. Lawyers, by virtue of their specialized knowledge in the law, are considered professionally competent to prepare these documents. So the act of preparing such documents can also be called drafting. Finally, you could also think about drafting as the kind of writing that lawyers do to achieve specific purposes. For example, a contract is not just a recognized form of writing that lawyers are professionally competent to perform. A contract also represents a particular purpose. When two or more parties have come to a particular agreement and want to make a record of that agreement and make it legally enforceable, they will approach a lawyer to prepare a contract that achieves that purpose. And a lawyer drafting that contract will have that particular purpose. So that's an overview of what drafting is. Now let's spend the rest of our time in this video reflecting on an important aspect of drafting, the distinction between the use of plain English and the use of terms of art. The point has already been explained in the reading material, but let's just remind ourselves of the importance of drafting in plain English. Why is it important to draft in plain English? Your writing is much more easily understood if it is clear. A person reading a document drafted in plain English is much more likely to understand what they are reading the first time itself. And that itself makes it a more efficient and effective form of communication. While writing in plain English, the effort is always to see whether the communication of an idea can be made clearer. So plain English is automatically about trying to remove as much legalese as possible. The question that I want to explore now in this video is how we can tell the difference between something that is legalese and therefore can be replaced by plain English versus something that is a term of art and so cannot be replaced by plain English. See, for instance, the term actus reus. Many of you may already know this term and have views about its utility in legal writing. Anyone who has done an introductory course on criminal law will be familiar with that term. So when we see it in a piece of legal writing, should we replace it with a plain English alternative? How do we analyze this question? We can start our analysis by looking at its definition in a legal dictionary like the Black's Law Dictionary. The definition for actus reus is a wrongful deed which renders the actor criminally liable when combined with mens rea, a guilty mind. Now this definition seems to give it a very specific meaning. While a lot of people might simply say that actus reus simply refers to the guilty act or a criminal act, its meaning is actually a little more specific. It is a term that is often used in the law and by lawyers in combination with the term mens rea to arrive at the basis for criminal offenses. So because of the definition and because of how the term is used, the term actus reus is more likely to be a term of art, one that we might not effectively be able to replace with a plain English alternative. Let's look at the next one, ex post facto. Once again, let's look for a definition in a law dictionary. It says after the fact, but there is some additional information provided. Refers to laws adopted after an act is committed, making it illegal although it was legal when done, or increases the penalty for a crime after it is committed. So there's actually two different ways in which it can be used. In the first case, it is a case of legalese that can simply be directly translated into English as after the fact. But if it's referring to a particular kind of law that makes something criminal or increases a penalty after the fact, well then, a plain translation is just not enough, and it is probably being used as a term of art. So this one is an example of how we need to look at the context to determine whether a term can be replaced by a plain English alternative. If the term ex post facto appears in your writing in the context of a law that makes something criminal or increases a penalty after the fact, then you should probably retain the term and not replace it with a plain English alternative. The last term we will look at in this video is inter alia. As we have done before, let us start by looking up the definition. It simply means, or it can be translated from the Latin into English as, among other things. Now, unlike ex post facto and actus reus, there is nothing specific to the law or a legal concept that this term refers to. I would therefore recommend that inter alia is not really a term of art. It is in fact legalese and can almost always be replaced with the plain English alternative, which, as you know, is among other things. Or in fact, as we'll see in some upcoming examples, it can actually be deleted entirely. These three terms have helped us understand how we can do an analysis to determine whether they can be replaced by plain English or whether they are in fact terms of art and should remain as they are in the drafting. Now, to understand this process of analysis better, let's look at these terms in some sentences. So this is the first one. Let's read it aloud. The proof of a criminal offense is usually dependent upon proof of elements constituting both the actus reus and the mens rea. Now, looking at that sentence, we see that there are two terms in there that are not in plain English. We ask ourselves, are these terms of art, or can we replace them with a plain English alternative? We've already analyzed the term actus reus. We've seen how it has a particular meaning in the context, and that it's likely that given the particular meaning, we would leave actus reus as it is in that sentence. Now, of course, when you're drafting, you need to think of who your audience is. If this sentence or the document that it appears in is actually going to be read by a lawyer or someone with some legal knowledge, you could probably leave it as it is. But of course, if it is going to be read by a client or someone who doesn't have the legal knowledge to know what actus reus means, you could leave that sentence as it is, but then you would need to go on to explain what those terms mean. Let's move on to look at the next one. The legislation was enacted ex post facto. Ex post facto, you remember, was the middle ground. It could, depending on the context, be a term of art or be used in a way that is strictly legalese. Remember what ex post facto translates to, after the fact. Let's see if the translation works. If I replace the term, the sentence becomes, the legislation was enacted after the fact. Okay, I think that works. This is an example of ex post facto being used in a legalese fashion. Perhaps if the sentence was a little different, for example, if it was an ex post facto law was enacted, then that may be a case of using it as a term of art to describe a particular kind of legislation. But that's not the case in this sentence. So this illustrates how you need to analyze these things carefully to know whether or not a particular phrase can actually be replaced by its plain English alternative. This was a case where to replace the phrase would actually make the sentence much better. The final example was the phrase inter alia, which as we saw is often used quite unnecessarily and so can easily be replaced by its plain English translation. Let's read the sentence. The manager must, inter alia, ensure that salaries are paid on a weekly basis. Okay, can we replace it with the plain English translation? The manager must, among other things, ensure that salaries are paid on a weekly basis. Now that works equally well, if not better, because there is no Latin or legalese. But what if we deleted it from the sentence entirely? The manager must ensure that salaries are paid on a weekly basis. I would suggest that that is better, unless in the context of the document or the section of the document that the sentence appears in, you need that phrase, among other things, then I would suggest that you could actually remove it entirely. It's just legalese fluff that's not necessary. Obviously, a manager has more than one responsibility. You will find such unnecessary use of terms very commonly in a lot of legal documents, and so you need to get used to weeding them out. I hope that this exercise has helped you understand how to distinguish terms of art from those legalese terms that can be replaced by plain English alternatives. I also hope that you've learned how easy it is to use simple plain English alternatives to legalese and how your writing actually becomes clearer as a result. So don't forget the importance of clear and precise language, whatever it is you're drafting, and whether you're editing or drafting, always be on the lookout for phrases that you need to perform this kind of analysis on. Thanks for watching.